Vacation, how can I do that?
I filed the IA yesterday, Lordship.
If it is coming under that notification, then it will be.
Yes, IA file, Lordship, that can be.
You take it, give it to the DR. If it is coming within that.
I want to mention.
Yes.
That I have filed a criminal message for compromise for confirming of the offences SC/ST Act. The victim has also already appeared. And
That's right, but is it so urgent?
urgent there because the NBW has been issued due to election drive.
Then see, there is a notification.
Yes.
Within that parameter, if the matters are reaching, those matters will be listed. Instead of telling me, better that you go and impress upon the registrar. I can't help it.
Matter has already been compromised.
That's right, you are absolutely correct. But give it to the take all the memos and give it to the deputy registrar. See if it is coming within that.
There is already compromise. I have 76-year-old lady. There is a young.
When have you arrived at a compromise?
2022.
22. Why in the vacation right now?
Because now the police is
Only Vijay Lordship sitting here. Vacation was there.
That's also my lord.
That is the reason.
That's correct.
What is the offense?
Blood offense.
3 SC/ST Act. There is only no
Yeah,
other offences are.
Just see if it's possible, list it on 28.
Well, consult.
Give it, we will try.
Right.
We'll try and yes. Any mentioning?
Challenging NBW. Next six.
When NBW was issued?
Sit around.
When was it issued?
Island, sir.
Huh?
Mention
Tell me
but
when NBW was issued.
I have no files.
You don't know when
Okay.
NBW is issued. It might have been issued in 2012 or 13. Now you are coming.
No, next sitting. For
Next
Arjun.
sitting, the bail matters, I don't know how many bail matters. Today I was just inquiring, 70, 80 bail matters. It's not possible. Bail matter. Wait. Okay.
Item
Maybe.
30. We have filed a connected matter. I am giving this number in the slip that may be called for minutes. Right.
What? Sorry?
Item 34 रे ଗୋଟେ connected matter ଅଛି के the number ଟା ଦଉଛି ଖାଲି record ଟା ଆସିଗଲା
I'll just see. Let it come.
Okay.
Oh, let it come.
Serious.
Yes.
Maybe pardon to make a mention, Milods. I'm appearing on VC. Milods, if my Milods recollect that CLMC number 1376, where that inadvertently that part in the order has been left out, the learned court master on the last date had said that he will correct it.
Yes. Then that.
But it is not done,
1
Milods.
minute.
Connected matter stay has been granted, but in that matter stay has not been granted. Matrimonial
For-
court also did that.
1 minute.
Matrimonial court also dictated that no stay will be granted, only notice will be issued. Just take a look.
I'll have to list this matter again. I'll just see.
Milods, on the last date,
Connected
Milods,
matter is a bail matter.
Hmm?
Connected matter is act as a bail.
the connected matter in which the husband has been granted the stay, Milods. It's a false
If-
case filed against the in-laws.
If in the connected matter stay is there, you must be enjoying that. Why? What is the urgency about it? I'll list
Milods,
it.
that is for the husband, Milods. This is the parents-in-law who are senior citizens, Milord, over 70 years of age. Now, summons
Matrimonial
will be
dis-
issued during
Matrimonial dispute.
matrimonial dispute, Milords. It's a false case, basing on which, Milords,
False, I'm not hearing now
Milo-
your matter. False or
my-
not,
your lordship is not
there
inclined
must be
to
some
grant-
reason why I have not given it.
No, Milords, in the petition of the husband, connected petition, Milords was pleased to grant stay because, Milords, the prima facie it was found out it was a
That's
false
right,
case.
sir. When you have that matter, connected matter was listed earlier. When the matter
Right.
your matter was taken up, it was heard, and I verified my staff that I have not passed the interim order. How do I
Milords-
remember? There is no
Milords, in-
point. I'll get it. There is no point. I'll get it listed. Just see listed. Okay, next.
Milords, listed out-
Okay. Let us see. Wait. Oh, we will list it. Don't worry. Yes. Next. Yes.
Item 1.
Yes.
Mentioning the bail matters, my lord. Appeal bails, it is a place matters.
I'll check with dear sir. If it is
List
To the
it.
dear.
Yes.
Grateful.
Yes.
Item number 1.
One. Yes.
item 1.
Item number 1, your lordship, it listed previously. Lordship may kindly.
So you didn't come when the matter was listed on 25 March, 21st May. You didn't come. Oh, it is now listed today.
Today.
Okay, okay, it's all right. Okay. Yes.
What happened in this case, your lordship, last appearance on that day, so Sao appearing through VC, my lord, asked me to take instruction regarding the submission of charge sheet, my lord.
Charge sheet.
What happened in the meantime, my lord? Since 21st, I did today, my lord, 23rd. Sundar,
My lord, here my clear submission, your lordship.
Hey, what are you challenging here?
I am challenging here, my lord, page
What
number
is the
14.
so pressing urgency in the vacation?
Because, my lord, it is a bail matter, my lord.
Either or, my lord.
My lord,
Yes, challenging question of-
indefinite
question
periods,
also also
they are, the
In the
petition-
482, you are in alternate, this court may grant bail. What is this? What is this prayer? Come to the prayer.
Either question or
No, either if you have a good case for questioning, I can understand. What is this alternate prayer? Alternate prayer has to be withdrawn and applied.
Your lordship, it is only prayer, my lord. Here, it is a good case for quashing. But, my lord, my alternate prayer is that, my lord, your lordship may kindly consider this application and grant default bail. Either
You are in custody.
in custody since 2022, my lord.
And I will record your submission and move application there.
Well, already I moved that application, my lord, before the learned court below. The learned court below disposed that application wide order dated, my lord, 14/12/2023. That order
See,
also.
what you are trying to say
that
is,
order challenge.
Challenge, I am saying.
you see,
That order,
you challenge and lost it.
that order challenged because the petitioner
appeal.
not submit, your lordship, because the petitioner not submitted sufficient answer, sufficient certificate. For that reason, my lord, honorable court
The
observed.
perusal of the record, because it seems that earlier rejection of the bail application of petitioner by this court
Answer for the
and which was
petitioner.
disposed upon such a respectfully has not been mentioned. You keep on concealing, keep on filing. Who will
My
give
lord,
you
I am
the-
not the counsel. I am.
Counsel? I am not telling you also.
And also,
My lord, in
this
this-
same order, my lord, he has
in
challenged,
this-
my lord, 14/12/2023, my lord. That order is challenged in this case, my lord.
No, please give me.
I'll
give me
I'll
evidence
just-
in my petition.
Paragraph 4,
I
my
am
lord.
not
My lord,
challenging.
can I see paragraph
I'll
4?
just issue notice. Let us examine and reopen.
My
Your
lord,
lordship,
paragraph
till
4
date,
likha hai.
they have not
Paragraph 4,
submitted.
my lord.
I know,
Para
I've seen
4.
it.
Your lordship may kindly peruse para
Para-
4.
Para 7 just see, para 7.
Paragraph 4 में लिखा है जी 14/12/23.
Mona
ये challenge को 14/12
14/12 এটা challenge করনি
One challenge that turned down.
Anyway, I am issuing notice.
My lord.
Let us see the
Your
charge sheet position will see. Because you are trying to say that insofar as this accused person is concerned, the charge sheet was not filed in the first instance.
My lord.
Charge sheet was filed insofar as the other accused persons are
Yes,
concerned.
ma'am.
And after 180 days,
My
in a subsequent charge sheet, you have been roped in.
Not.
So therefore, that 180 days time has lapsed insofar he is concerned. So 160.
One thing,
That's what you want.
my lord, before that, I want something, one thing, my lord. My lord, charge sheet, my lord, they submitted 4 persons are arrested, my lord. Since 128 days going to expire, my lord, the IO submitted charge sheet. In between that, he has been arrested and remanded in the custody in some other cases, my lord, 13 cases, my lord, against him. My lord.
Not in this case.
Not in this case, my lord. He has remanded in this case. When my lord remanded, by the time Congress Parliament.
So then you have to file the reply. You file the reply.
Your lordship, just I am replying to. Since my lord, the
I will have to
How
continue.
do
30 second I will take, my lord. The FIR registered on 9/6/2022.
When you are taken into custody in this case,
Contains custody, my lord.
in this case,
In this case, my lord, that is a 3/8/2022.
from that day 80 days has to be calculated.
Prior to filing of charge sheet, they pray for remand, my lord. After filing of charge
All these
sheet,
things
the
it is-
remand granted, your lord.
Just check it
But-
up. We'll see. Immediately after. Yes, next.
FIR हबार गोटे दिन पर अरेस्ट करछन्ते अन्य गोटे केस.
We'll see. We'll see. Yes.
Item 2.
Item 2, my lord, is a compromise matter, lordship.
Hmm.
And I pray, lordship, the lower court, my lord, posted to the framing of charge on 30th, my lord.
Hmm.
Lordship, I pray, my lord, next sitting, my lord, lordship, I call for both the petitioner and
Why we will wait for the
my
parties
lord,
to
my
come?
lord,
You said that the vacation I listed it because they are supposed to come.
my lord, lordship, next sitting, I
No, no,
pardon,
no.
my lord, lordship, otherwise, my lord,
They
the
will not
CRLC,
take the court granted.
my
Because
lord,
you are settled, you are coming, the accused persons are coming, please wait.
my lord,
And
sorry,
come,
my lord,
today midnight, come at 12 o'clock, I'll wait for you. What is this?
my lord, sorry, my
Vacation
lord,
I
I-
accommodated, You
Well,
told that I am bringing
well,
those people.
I presume that matter will come on 28th, Lordship. That's a
How
matter.
have
I think,
you
my
written?
lord.
I have written that.
My lord, Lordship, I pray next sitting, my
Let it
lord,
come,
authorize infructuous. The
Let it
matter
come
will be
immediately,
infructuous.
immediately after vacation.
28th, Lordship, I pray. My
Immediately
lord.
after. Settlement matter, what is it now?
My lord,
Yes.
authorize infructuous. My lord, framing of charge posted on 30th, Lordship.
Even after framing of charges, if you have settled, I will quash it.
Right.
Why do you worry?
People are asking me for me.
No problem. You remind me, even charge is framed. If you have settled the dispute, I'll quash it. Okay. Don't worry. Yes.
Item 3.
After vacation. Why you got it listed then?
And what happened in this case, my lord? Who accused also prayed for any another CRLM 854, same prayer, my lord, and that has been adjourned to 20, 26 my lord, that has been adjourned, my lord. 854.
Connected matter.
Connected matter.
Attack or the 854.
854.
26 ଯାଇଛି ବୋଧେ
854.
85 to 24 ସେ ଯେବେ ଯାଇଛି
Yes, next.
Item 5. Item 4.
4. Yes.
My lord, item 4, my lord, I am in virtual, my lord, virtual court.
Yes.
The accused persons are present, my lord. The complainant has compromised the case. I have received the money by the annexure 3, your lordship, money receipt. And
Where is the complainant, sir?
my lord, she was appeared when the against the principal accused.
From opposite party, man.
And told that I don't have any objection if other accused person. You have no family members, my lord. The Ishwar Chandra Swami is the father, and they are the wife.
Right. See, you just understand one thing. This is a case arising out of a complaint case, 1CC case. Okay.
Yes, ma'am.
If the complainant herself will not come to the court on the ground of settlement, how can I quash?
My lord, filed affidavit engaging an advocate, my lord.
No. We have to see him. Tomorrow he'll say that it's not my affidavit. At least this much is required. At least the complainant has to come.
And your lordship also quashed the cognizance against one Ishwar Chandra Swami in same case, my lord.
I don't know. Where is that order? In that case also complainant didn't come.
No.
Where is that order? The one which you are referring?
Yes, my junior.
Why you are appearing for opposite party?
Yes.
Where is he?
आज contact ହେଇପାରିଲାନି କହିଥିଲେ ଆସିବା ପାଇଁ
Then
ସେ ଆର୍ଥରକ ପ୍ରେଜେଣ୍ଟ ଥିଲେ ମାଇ ଲର୍ଡ
presently that's a different story.
Ishwar Chandra Swami is the principal accused against whom cognizance your lordship passed. He has returned all the money, the 22 lakhs, along with the 3 lakhs interest and other things.
Each one. See, the complainant in this case, complainant has taken 22 lakhs. It's all right. How do I know that this complainant is not expecting anything from these accused person?
25 lakhs she has taken.
That's right, sir. It is the petitioner in that case, Ishwar Chandra Swami. She came and told the court that yes, I have received 22 lakhs. How will I know that these accused persons, those who are present today?
Yes, my lord. They are the family members of Ishwar Chandra Swami.
Yeah, Mr. Ragada, just see what to do.
My lord,
See,
Compare.
there were,
Correct.
I'll tell you, there were 4 accused
my
persons.
lord,
The first this petition was filed, ICC case.
my lord,
First this petition is filed, Ishwar Chandraswamy, main accused,
my lord,
came before this court. I quashed it, saying that they have
my-
settled their
my
dispute.
lord, my lord,
And 25 lakhs was dispute,
my-
22 lakhs she has received and she is satisfied.
my lord.
I recorded that and I quashed
Then
it.
let's say 22
1
lakhs,
minute, 1 minute,
my lord.
quashed it. Now the other 3 members of the family have filed this petition.
My lord.
They are present, virtual mode.
She has shown arbitral can pass out.
That's the whole difficulty.
They have
Tomorrow she may
he
say,
has to came forward and file a joint affidavit. That is matter. I have no objection if the case pass.
that's the
Otherwise,
problem. Technically you have a problem.
There is no complaint case, na?
Complaint case, na? Problem as you.
Stay around.
What I'll do is, I'll record the presence of these 3 accused persons today. Let them not come, but let the complainant come. I'll do it on 28.
And joint affidavit they will.
Bring the complainant on 28.
ତାଙ୍କ against compromise କଲେ କିଏ କଲେ pass ହେଲା ନା?
କହିଲେ ଯେ ଆମେ ଥରେ ଯାଇ କହିଲୁ ଯେ ମୋର କିଛି ଅବଜେକ୍ସନ ନାହିଁ ବୋଲି ପୁଣି ମତେ କାଇଁ ଡାକୁଛନ୍ତି
ନା ନା ସେଟା କଥା ସେଟା ସେତେବେଳେ
ଆମେ instead of 22 lakhs lawsuit
That day, why you have filed for 1 person? Why not for all the 4?
ସେଟା previously filed settled ହେଲା earlier filed but settled later on, my lord.
Okay, least it before when after vacation. Yes.
So your lordship may issue notice to the complaint.
Issue notice to the
Issue notice to the opposite party. Yes, my lord.
I am issuing notice.
Issue notice to the opposite party, my lord.
If she doesn't come, then I can understand. I can.
Yes, yes, my lord. Yes.
Okay. So they record the 1 minute. They record the presence. Where is the item 5, na? Item 4.
Item 4, my lord.
The order at the amount. I'll have to record it, otherwise again. Right. The petitioners are seeking quashing up for the proceeding in ICC case number
8170.
ICC case number 8170 of 2022, initiated by the opposite party for alleged offence under section 8. There are 4 accused persons in the present case. The accused number 1 is Chandraswamy filed a petition before this court, being CRLMC number 4396 of 2023 on the ground seeking quashing up for the complaint case.
4396.
Matter has been settled. By order dated 7/5/2024. The complaint case qua that petitioner has been quashed. The present 3 petitioners, being the co-accused in the ICC case, have filed separate petition. The accused persons are present in the court today through virtual mode, and being represented by their counsel and identified by him. However, since the complaint is not present in the court today, quashing up of the ICC case qua these petitioners is not possible. Hence, issue notice to opposite party number 2, written order. Okay. Better order, written everything. If even then she doesn't come, then I'll quash it. Yes.
I may be pardoned, my lord. Kindly give me permission. I will only say one thing, my lord. Kindly give me permission.
In this matter.
No. Once came compromise matter, my lord has an order on 20th, then 21th, but it has not been listed. Party is present, my lord. Already court was present.
You have given memo. We have not said.
No, I have given memo, 2 memos.
What is the offense?
Offense matrimonial case already. Mane both the young persons are gone to the
What
law.
is the offense I am asking?
Offense 294, 506, 354. This is type of 34.
They are married.
Yes, merit. Law, tribal. Party is present, man.
Why it was adjourned to July then?
Party mu ani chhe kya? Party ani chhe.
Party हिसाब रे कोर्ट चली बने क्या?
नहीं.
Party पुलिस इसलिए कोर्ट. That day, why did you bring the parties and then?
No.
I got it adjourned. Because nobody came.
No, I am not saying, my lord. My lord is saying if party will come, compromise matter.
Then you do a fix a date, I'll go to their house and pass the order. That's better idea. Why should you bring them?
My lord, another date, ma'am, fixed, my lord.
That's a good idea.
Party.
We are not waiting for the parties to come. You certainly you bring them. You didn't bring, therefore I adjourn it to July. Now
No.
in vacation you are coming.
No, man. Party is present today.
I
Evening.
can't prepone that date.
Yes, my lord.
On that day, let it come.
13 July. My lord, it was a long day. Police is apprehending to arrest the petitioner. Attitude କାଇଁ ଯିବ ଏଟା compromise case ଟା
Compromise ତ ସେଇଦିନ କାହିଁକି ଆସିଲେନି?
ସେଦିନ ଆଜ୍ଞା ଆସିପାରି ନଥିଲେ ଲିଷ୍ଟ ହେଲାନି ବୋଲି ଆସିପାରି ନଥିଲା ଆଜ୍ଞା
List ଥିଲା, that matter was listed, therefore I adjourned.
ନାଇଁ ଲିଷ୍ଟେଡ ହେଇନଥିଲା ଆଜ୍ଞା ଲିଷ୍ଟେଡ ହେଇନଥିଲା
Memo was
Memory.
the first date, it was adjourned to July because of non-appearance. So
You didn't appear, that's the old difficulty. We'll see.
Coercive item 4 your lordship may say no coercive action taken till that. Against the
He made record there no course. No course, yes.
obliged.
No.
Item 5.
If possible, I could have done it, but the date is there, therefore it's not possible.
Item 5, my lord.
Was last listed on 51st.
20 item?
5 months.
Yes.
The refusal to provide certified copy. The improved order is at page 15. So,
What do you want?
admirably against issued against him, he applied for absconder. File Bhoklatnama and applied for certified copy. That has not been given.
Forget it. Tell me NBW, when NBW was this?
11 January 2020.
Right only. You are not, the petitioner was
Not in
abscond.
bed, not in
Petitioner was abscond. Therefore, on the, in the request of IO, NBW.
No, no. Ayo.
No?
Charge sheet to submit.
Fact तो कम से कम को भाई.
Set up.
You don't know.
41 actually.
Huh?
41 ଯାଇଥିଲା
Ah.
ଆସିଲା
Well,
someone
petitioner was on the notice under section 41. Okay? Subsequently, NBW was issued by the court below on
11 January 2020.
in 11 January 2024. हाँ. ये कौन सिविल लिखने दो? You say quash the order dated 25/4/2024. What is this?
ସେଟା ତା ରିଜେକ୍ଟ କରିଦେଲେ ଆପ୍ଲିକେସନ ଟା ସାର୍ଟିଫାଇଡ କରିଦେଲେ
Okay. Issued on sunset day. Huh? The petitioner applied for the certificate copy of the order. While the impugn order dated 25/4/2024, the said application was rejected. Therefore, the present petitioner is aggrieved and filed the instant case. Right down. Okay.
ବଟ ଜଜମେଣ୍ଟ ଅଛି ହେଇପାରିବ କରିଦେଲେ ସେ ଆଉ ସେ ମାସିଟା ଆଉ ଭୁଲ କରିବେନି ଜଜମେଣ୍ଟ ଅଛି
कौन
ଚାନେ ପଟ୍ଟନାୟକ ଯଦି ବି ଆପ୍ଲାଏ କରିବେ ଭୋକଲାତ ନେବେ ଦେଇପାରିବେ ପାରାଗ୍ରାଫ ମାନେ ଯଦି ମାନେ
trial court rejected.
4 ର ସପାର 3 ଟା
Trial court rejected the application. Where is that order?
S 50 ବେଟର ଗୋଟେ ଯିବେ
Huh?
ଆଉ କେହି କରିବେନି
50. कौन लिखा है की?
The court by which order dated 25/4/2024 has not accepted the wakalatnama filed on behalf of the accused. In absence of accused against whom NBW is pending for execution, as learned advocate is not entitled for
Right.
purpose of
कौन लिखा? नहीं वैसे लिखो. Petitioner, the petitioner engaged counsel. Counsel who filed wakalatnama before the court below. The same wakalatnama was not accepted by the trial court on the ground that NBW has already been issued. In the absence of the accused presence, the wakalatnama cannot be accepted. Then counsel for the petitioner relies upon judgment of this court in so and so. Which para?
4 ର fourth ସପାର 4
Emphasize in para 4. Para 4 which reads as on the basis of this judgment, we say that the court ought to have accepted the wakalatnama even in the absence of the accused person. In that view of the matter, the impugn order dated so and so, passed by so and so is quashed. Okay. Yeah.
Item 6.
May I please, Your Honor. Here are the doctors
quas, and the trial court is directed to accept the wakalatnama filed by the petitioner. Okay. Yes.
Here is the anesthesia doctor and two others has been charge sheeted under section 304 and 34 IPC. Operation was conducted and the patient.
Anesthesia doctor.
Yes, my lord.
Both are anesthesia doctor? No.
Anesthesia doctor and 3 is the nursing home owner.
Nobody is responsible, according to you.
Then
Then
30.
cases may be different insofar as all the three cases.
They are not provided, my lord, the ICU did not, there are other.
There is the allegation. And
Allegation
that,
only at this says.
and 304 and 34 of IPC. That will be
Allegation.
medical.
But only says-
negli-
Charge sheet filed.
Yes, started cognizance
You are
taken.
challenging cognizance.
Yes, man.
Simply issue notice.
Stay of further proceeding, my lord.
How can I say?
304.
Just to
ये पे 304 है,
Then what is made out? You tell me.
304 adverse.
What is made out?
304 है और 30 but medical negligence.
Then you have to argue on charge. Shall I give that opportunity to you to argue on the charge? This
Notice.
charge is made out or that charge is made out? You can argue that.
On the Supreme Court has passed the cognizance order.
First of all, you should not have filed a single petition because allegation against all the
No,
you
all
are inviting problem for yourself. You should have been well advised to file separate petitions.
doctor,
You club all the accused persons. And
he has,
allegation against one accused person
Then
will be raised against other.
he has named one doctor. He is not the petitioner.
I'll tell you,
And- Yes,
I'm not
I-
holding brief for you,
No,
but
no,
it's
no.
better that you withdraw it and file separate petition.
Little better.
It's always better for you.
Doctor, doctor.
Because the allegation against all the three are different.
Oh,
One of them might be, falsely implicated. The other two,
other two, as because in his nursing home that was operated.
anyway, I'm just issuing note.
Okay.
Issuing note. Yes.
Item 7.
Lordship, in fact, review at all, a notice should suffice for me because unless it compromises and that steps are taken, Lordship, and because of
What is the offense?
offense, Lordship, serious offense, allegation are very severe. Yes, Lordship.
I
but-
simply issue notice.
Lordship,
Let's see.
but I'm a teacher, Lordship, in vacation will grant me some protection, no course of action, that will suffice, Lordship.
No, no.
Otherwise,
Allegations-
that-
You are a teacher.
I am a teacher.
You have done
Lordship, Lordship, that allegations are I have gone through, that is, unless it is compromised, there is nothing to, Lordship. And that step is taken, they are ready to go, because of ongoing election in Lordship, Western Odisha, because 20th the last day, they're supposed to come to, supposed to come.
Probably
to
I-
Lordship.
I should application rejected.
Anticipated,
That's
but
the whole difficult
but
idea.
no warrant, nothing,
The
nothing.
reject.
Reject it. Yeah, that is.
How can I
Only no course.
sabotage that order?
No coercive.
That is again sabotaging that order. You burn your finger by going there and getting an order against you what to do.
I have reflected, Lordship.
That is not difficult. And otherwise also police are busy for election and all.
Election. No, police, but after this counting, 4th June, they will be free. After counting, they'll
Immediately after notice, immediately after the
vacation.
Immediately after.
Lordship. Grateful.
Yes.
Item 8.
May I please, Lordship.
Yes.
Lordship, as per the direction of last occasion, my Lordship, I am filing the NBW order against the present petitioner in IN number 1432, 1432,
And I 14.
32. That is available on record, my Lordship.
NVW issued against you.
Yes, well, along with 3 or 5 other person, my Lordship. That I am not in bail, my Lordship.
You appear. When do you want to appear? I'll say it and go and appear.
My Lordship,
Okay.
Lordship, I am not in bail along with the other petitioner.
What are the offenses?
302 and 147.
So the only thing is I can stay this execution of NVW. You go and appear as much as time you want. I will protect you. 1 month, 2 months.
It is submitted is going in at the abscond.
My Lord, the
Now
purpose
trial
of
is
this,
going. That stage he is praying.
my Lord, the purpose of this filing of this application, my Lordship,
Sir, charge has been framed.
Yes, ma'am.
Cognizance taken.
Yes, ma'am.
Charge frame. Evidence
Yes,
is going
yes,
on.
ma'am.
You were absconding. Today, you
After-
tried everywhere. Thereafter, you file a 480.
my Lordship,
after the verify the evidence, the three numbers of eyewitness are there.
You don't say that because at this stage,
Well,
I can't go into the evidence already recorded by the court below.
well,
The evidence which is going on now, being trial is going on, that evidence I can't go into. I can't scuttle the trial like this.
well,
The best thing what I can give you is I'll stay the execution of NBW. You go and appear and avail your remedy.
if I am appear, my lord, I am definitely go
What can I
behind the bar, my lord.
What can you an accused and 302? What can I do?
My lord, that entire case arising out of political mess. The witness
That
are
you can argue, sir, at the time of bail,
Argument,
grant of bail.
argument.
Definitely, you will get the bail also. Definitely will get. You should get bail because of the nature of allegation against you.
Well,
You get bail. It's better that you
but
tell me how
prior
much
to the
time,
bail, I am definitely going to the
how much
court.
time you need. 30th June or little more than that.
If possible, my lord, more than that.
Possible, you tell me. If it is reasonable, I'll make it 15th July. Okay. 50 on or before 15th July, appear, move appropriate application. Till then, the NBW issued against you shall not be executed. Right on.
And my lord,
By
do
order
see
dated
accept.
9/9/2023, NBW has been issued against the petitioner. Upper the petitioner is been accused also and shown as an absconding. Learn counsel for the petitioner has taken me to the evidences recorded by the court below in the trial or on the ongoing trial against the co-accused persons. He submits that on the basis of this, the quality of evidence which has come on record, it is evident that no case is made out against the present petition. Therefore, he seeks indulgence of this court for passing up the entire proceeding against him. I am not inclined to interfere in this matter. However, the NBW issued against the petitioner by order dated 9/9/2023, execution of NBW issued so and so shall remain stayed till 15th July 2024. The petitioner shall appear before the court. Petitioners shall appear before the court on or before such day and move appropriate application. The same shall be disposed of by the court below in accordance with it.
Mercy, one more prayer, mercy. Mercy, when he appears, when the petitioners are appear before the London trial court, then mercy kindly issue order that the matter was decided in the same day, if possible, first of
I'll tell that the moment they'll appear, acute everybody.
No, mercy. That only one prayer, mercy. The same day decision.
Why are you making
Because
a prayer? It's not
mercy,
possible.
I have the ground.
So then you won't tell that
But
to that court.
if consider that the CD was called for, then I may remain custody in more than 7 to 10 days.
If such application is moved, the trial court should do well to see that the same shall be decided as expeditiously possible. I can't do more than that. Please understand.
If matter is possible, same
On
day
the same day,
disposal.
okay.
Mercy,
On the
same
same
day.
day.
Mercy.
As expedient, category on the same day.
Oh, bless mercy.
This much indulgence because it's not possible to give more indulgence.
I am praying before you, mercy. That's because I have sufficient
This
ground.
is also a bad order
Yes.
in the sense that I can't control the board of the trial court every time.
If mercy may appear in the
But
court,
still,
appeal,
this is hard
then I
case,
have
so
sufficient
in
ground.
hard case, therefore I have given indulgence. Be
Mercy.
happy with that. Okay.
Mercy.
Yes.
Oh,
Item
bless
nine.
mercy.
May I please your lordship, I am in virtual mode. My
Yes,
lord,
sir.
my lord, this case is covered that 205 rejection and PMO case.
This is not covered, my lord.
Yes,
This
yes.
is not covered. No. Your
Please,
lord,
please.
here, my lord,
Hmm.
my senior is challenging order passed by the trial court under section 205.
Yes.
Yes.
Trial court has not issued he can go appear and submit bond. That's a different question.
No, that is
But
why.
whether trial court reject.
Mr. Agarwal, please wait for me.
Yes,
Let me
yes,
complete
yes,
my submission.
yes,
Let me
yes,
complete
yes,
my
yes.
submission.
Yes.
Please,
Yes.
please
Yes.
allow the petitioner at least to address. Then you will have a chance. My lord, here is a case where after the summons were issued, after taking cognizance by the special court, summons were issued. In response to the summons, the petitioner filed a application 205. So that was rejected. Against that, I preferred this present CRLC. Now, in the meanwhile, pending this application, the Supreme Court judgment has come. Now, in fact, Lordship have already allowed petitions that the petitioner would be making a fresh application 205.
Then in that case, Why don't you withdraw with the liberty to move to 205 in accordance with the
Court has fixed the matter for their appearance. They can go submit bond and go. That's a different question.
Let me complete.
Yes,
Mr.
He
Agarwal.
wants to withdraw with that statement. I'm
Yes.
recorded and dispose it up. Right.
That is what, in fact, my lord, in another matter, 3009, Lordship have passed the similar order saying that permitted to withdraw the petition and make its application in the light of the judgment of the Supreme Court, and that shall be considered under the.
I'll record your statement. I'm disposing it
My
up.
lord,
You do
in
whatever.
that matter, the facts were different. Here, trial court has passed a detailed order. Your lordship kindly see, a 13-page order has been passed by the trial court. To grant exemption is the discretion of the my lord trial court. Trial court exercise jurisdiction. He can go on bond. That's a different question. But whether he has made out a case under section 205 or not, that is the
Court will
question.
see, the regime has now changed after this judgment. So
That's
therefore,
why
he
I'm
wants
saying
to take a chance.
he can go submit bond and go. I have no objection, my lord. That he can go submit bond. That's a different question. But question is whether a blanket exemption can be granted when the trial court has exercised power.
I don't know why.
But in the same time, it is his petition. He wants to withdraw.
Yeah,
I
that I have
have to record his statement.
that he can withdraw.
I'm
and
recording
go.
his
Yes.
statement. I'm not saying anything. I'm
Yes.
recording his statement. It is his petition. He wants to withdraw.
He can with that he can
Nobody can
withdraw.
stand in
Yes,
his
no.
right now.
That I
Mr.
And in view, only submission would be in view of the Supreme Court direction that is to be carried.
I'm passing that. Manas Mahapatra, learned senior counsel for the petitioner, seeks to withdraw this petition to avail a remedy, to move a fresh application under section 205 in view of the recent judgment passed in Tarsim so. I'll stop it here.
not only section, because he is to appear and give bond also. In your lordship may say he may file a fresh application in view of judgment passed in a year.
And the same shall be considered in accordance with the law.
Yes, no.
If
Everything is written in that
the same shall be considered in accordance
forgetting.
with the law. With this liberty, the petition is disposed of. Yes. Yes.
Item 10 also similar.
Same.
10 same.
I don't know why he is becoming hyper.
No, I am not hyper. Because the facts of that case, there, my lord, NBW warrant was issued. Here, warrant and court has fixed for appearance. He can go submit bond, he can go. I have no objection to that.
Slowly, I think, this the new judgment will be streamlined.
Yes, my lord.
How in the ground it is acting.
Actually, this judgment, my lord, if your
Pending the Supreme Court judgment.
number of directions has been given. Supreme Court in that case had specifically said we are passing this order in a peculiar circumstances of this case. In that case, my lord, NBW anticipatory bail was rejected. NBW was issued. So this order was passed. Here that stage has not come. Here court rejected his 205 petition, asked him to appear. So he can appear, submit bond in view of this judgment.
I think you are not appearing in the trial court.
I am appearing in the
He is
trial.
appearing everywhere. He is appearing everywhere.
Trial court also.
Even before the
That's why
ED is
detail of in this case,
Sir, you are not in safe hands.
my lord, that's why a detailed judgment under section 205 has been passed by the trial court below.
My learned friend, in fact, is not reading that para 23 properly. What
I have read it. Sorry, I have read it, but not only para. Thrice I read the entire judgment I have read.
Sir, the best thing is you have to take the itinerary of Mr. Agarwal, vacation itinerary. There in his absence.
He's a brother to me for last 30-40 years. So there is no question of. So the question is, he is becoming more anxious about this thing.
No, I am not anxious, but that's not
because
correct.
earlier regime was smooth sail for him. Now this judgment is creating problem.
No. And now in last 2-3 matters I accepted because here, my lord, facts are completely different. Here it is not a case that these petitioners can be allowed under section 2. They are resident of Bhubaneswar. There is no problem for them. So they can go. They can go and your lord, they can go submit bond. They can go. That's a different question. I have no objection. But can a 205 blanketly allowed? He used to make out a case for a 205.
My learned friend is
Let's
forgetting
see
one thing.
how he's making out now.
He is forgetting that the second case, the client of mine is a member MLA. Now he is contesting the election. So how can he say that 205 is not required?
Good.
Both the cases similar.
Both are. Your lordship may record my appearance.
No,
Item 11.
Item 11, Your Lordship, I may be pardoned. Mr. Anupam Ratlanit, senior, who's appearing in this matter, he has fallen sick from yesterday night, Your Lordship.
I simply attend that.
I am praying for 28th, Your Lordship.
Huh?
28th, Your Lordship.
28th, I don't know. What is this? So, what is this so urgent?
Your Lordship, my account has been freezed pursuant to direction from the cyber branch
When the account was freezed?
on 3rd of May, Your Lordship. I do not have the file. I apologize, Your Lordship. I saw his.
3rd of May, you tolerate for such a long
No,
time.
no, Your
Wait for
Lordship.
some time.
No.
And investigation is also going on because that is fraudulent transaction.
Your Lordship.
20th of immediately.
Your Lordship, one submission, Your Lordship. If the amount has been refunded, it was mere 10,000 amount. The complainant had lost on a gaming app. It was from a sub merchant. I am the payment gateway, master merchant, Your Lordship.
Investigation is going on.
Your Lordship, they have been saying that we have been following up thereafter till the filing. They have been saying of that, but they are not giving any details or anything.
On the request list on 20th. Huh? Okay. Yes. Next.
Item 12.
On behalf of Mr. Nanda, after vacation, Your Lordship, this matter.
Why are you getting it listed in vacation?
My lord, automatically some matters has been listed, Your Lordship. I have also one matter.
15/5. Whatever is filed will come.
Kali number hichi aji list hichi.
After 13th, whatever petitions are filed, those matters are coming. So, that's the reason it came. Okay.
Serially.
Urgent. On request. Yes.
13.
My lord, it is a for quashing of affair. On that day, both the doctors have came.
But that case, my lord, both
Acha,
are
acha,
doctor.
acha.
Only you have to ask the co-accused who has not come.
Where is the co-accused? Where is that order? Where is that order? Give me that order. The one which I
Order बाहर नहीं number दे दो 3601 of CRLM से 3601 of 23
3601 like 3601 रे order ಕೊಡ್ತೀಯ
of 23
counter case
you are the petitioner. This is the counter case, no?
Yes, Dr. Sangeeta Behera.
There are one accused here, my lord, two accused. But that is you have to ask. Want to know the
Co-accused is
appear or
here.
not? Yeah.
FIR number 127 of
Same FIR.
23. Yeah, I would have counter.
What is his name? He is the
Kuna Pathan alias
he is
He is outsider, my lord.
He is outsider.
He intervened in between the quarrel between two doctors, my lord.
Petitioner's name I'm just looking at.
Petitioner name Dr. Sangeeta Behera.
Sangeeta Behera is the
Opposite party.
He was the
Informant.
In this case, you're talking about
In this case.
In this case,
Also, Dr. Ansuman Sahu is the informant.
Informant.
that case, there should quash. They are the Sangeeta is the informant, my lord.
Now, in this case, who is he? Who is he?
He is co-accused.
He is co-accused.
What is his name?
Kuna Pathan.
Where is he? He's not a party, therefore I'm wondering.
Party question.
Kahin?
Oh, party.
Sech में तो रहला.
अब कौन file कर दूंगा? Just I'm.
No, I have filed another petition for him.
Where is that petition?
But due to this original FIR copy attached with this, that is in defect list. They have not clear it. Yesterday I have told him.
Huh?
He has mentioned, my lord, that was in defect list. He asked him to
Call it. I'll take it. Call it. Let it come. I'll call it. Call the file into this one. Yes. Wait for some time.
Yes,
He'll call the file. Send someone. Yes.
Item 14.
I am looking at this Sangeeta, Dr. Sangeeta. This is the old matter.
Yes, ma'am.
Yes, 13.
14.
14, madam. 40. Yes. 40.
May I please, your lordship, my lord?
Yes, sir.
My lord, the swindler that swindles away my 7 lakhs odd money, my lord. I made a complaint before the opposite party number 2 during investigation. She's the account. I made an application before the court having session over the matter which passed the order. May I invite to lordship's kind attention to place 44. There is crystal clear direction to effect release of the money. But though in the meantime, time has been fluxed, the OP number 2 has not taken any step. You'll mind, prescribe lordship, my lord. OP number 2 may be directed to take effective step for in compliance of the direction. Page 44.
Court can act as an executing.
No, that is all the way there. That I'm not saying.
Or was has already
That,
been passed.
that I'm not saying.
There is an order, I comply, kam khatam.
Oblige the problem.
My lord, is that my prayer can.
90% cases we are fighting on technicality only.
But I'm not that.
Main dispute, you address that dispute, forget
Yes,
about whether.
that is.
What is it? My lord, can be.
Yes.
I am
Oh, say it not I for
my lord, can see that I may be.
very ticklish point my
Court of my.
What does?
I am not press.
No, yes, passed.
I'll simply issue notice. I'm expecting that the order passed by the court below is complied.
The problem.
That is the expectation. If you have not challenged that order, you have to comply.
Oblige.
That's what he says.
Yes.
If you have challenged, that is a different story.
Yes,
If you have not challenged, that
Yes,
order has
Lord.
attained finality,
My lord.
you have to comply. He has come to this court.
Yes,
This court may not be an executing court, but still the fact remains that you have to comply. Why to go into all these things? I'll simply issue notice.
Prayer that he has stated that not to take immediate steps to release the.
No. To take not to.
I will
Oh, well.
nothing.
Which order you want to get it complied? That is the page.
Yes, 44. ma'am.
Order dated 4/5/2020.
Yes, 44.
What is the order? What is the order? Accordingly, they are directed to issue necessary to branch manager for the concerned bank to defreeze. Mention account. Defreeze.
Defreeze and release. That is IO.
Right.
Yes.
By
IIC.
impugn order dated. Impugn order dated. This was passed on your application.
Yes, my lord.
By impugn order dated.
Annex 2.
4/5/2024. The application moved by the petitioner under 457 was allowed and following direction was made. ये para 44. Page 44. Page 44. ये table दबा दो कर खाली एड़ा कर दो. Table दबा. Page 4 ना order. তারপরে table আছে table দবো. ঠিক আছে? Then counsel for the petitioner submits that despite order in specific terms, the same has not been complied as yet. Therefore, he is agreed. So and so appear for opposite party and submits that while exercising jurisdiction on 482 CRPC, this court may not act as an executing court. Without going into the controversy subject and disposing of this matter with a direction to the concerned authority, direction to the IAC, cyber crime and economy offense of which PS?
Party number 2.
I am directing opposite party number 2.
Yes.
Directing opposite party number 2. We comply the terms of the order dated 4/5/2024 as expeditiously as possible.
Short time. Money has been taken.
As expeditiously, preferably within 1 month. If the same order is not challenged by the opposite parties. Yes. If they have challenged, they can't.
I have not. That I have written in my petition.
If
Oblige.
not challenged. With this
The amount involved, your lordship may reflect.
that I have written.
Oblige.
With this observation, the petition is disposed. You comply it. If you are challenging it, it's a different story. If you don't challenge, comply it. I'm not saying anything. Yes. Yes.
Urgent.
Urgent only.
Oblige. Oblige.
Item 15.
My lord, quashing of the criminal proceeding on the ground of compromise, your lordship, matrimonial dispute offense.
Where are they?
Lord, but list of only जाननतले सडन पले असला मु intimate करिनी. Notice may be issued to the opposite party, your lordship.
If settlement matter is 498, you
Lord,
bring,
you have
can you
to-
bring it today?
No, my
Online?
lord. No, my lord.
Issue notice to.
I file a IA for stay of the,
You file very, show me where you have settled.
my lord,
Compromise.
my lord,
joint affidavit,
they have a
everything.
mutual divorce petition has been filed. They have that has been allowed, your lordship, marriage of the year 2012.
Why this matter?
Page-
Same reason.
Page 30, your lordship,
That
kindly
counsel
see.
for the name. Then counsel for the petitioner submits that this dispute is arising out of a matrimonial discord,
Right.
and the petitioner number 1.
1 and 2 both have filed mutual consent by way of
Who is the wife? Who is the
petitioner opposite party number 2.
opposite? The marriage between the petitioner number 1 and opposite party number 2 has already been dissolved by a decree of
My lord, petitioner number 3 is the husband and opposite party number 2 is the
3 and 2, petition 3 and 2 dissolved by mutual consent by a judgment dated 27/4/2022 passed in civil suit bracket MAT number 14 of 2019. The parties have settled the dispute. Pursuant thereto, the marriage between the marriage between petitioner number 3 and opposite party number 2 has been dissolved. Therefore, the petitioner is seeking, petitioner has filed the present petition seeking the entire criminal prosecution initiated against them. Issue notice to opposite party number 2, returnable radio, and the next time, in the meantime, proceeding before so and so is stayed. Yes.
I may be pardoned, Your Lordship. Lordship, in item 11, Your Lordship is directed to be listed on 20th. Yes, Your Lordship, I may make a small prayer, Lordship. Your Lordship, I call for instruction in that matter, for a report, Your Lordship.
First matter?
Yes, Your Lordship. Fresh.
Notice for this.
Your Lordship, state has taken instruction that an investigation is going on. Let them submit.
Notice was not issued.
No, dear, no.
Issue notice to opposite party number 2, and opposite party number 2 directed to seek instruction regarding the status of investigation.
Yes,
And please
Obliged.
by next day.
Matter para 1, he has stated that no PS case has already been registered.
I have said that you say whatever you want to say. How does it make difference? I have only issued notice.
But instruction, there is no PS case has not yet been registered.
Still, they have freezed my
You
account, Your
simply
Lordship.
say that PS case is not registered.
But in para 1, he has stated.
You say that one next
Your
day.
Lordship, they are not registering a PS, but they have freezed.
All right, I have whatever you want, I did it. How does it make difference? Let them come. We'll see on that day. Okay. Yes.
Item 16.
May I please, Your Lordship?
Yes.
Well, that's item 16. Here I am assailing the judgment dated 11/5/2024, my lords, passed by the learned additional sessions in Gunpur, whereby the present appellants, my lords, they have been sentenced for simple imprisonment for 2 years under section 1.
15/5/2024.
11.
No, 15/5. Judgment you have annexed at 15/5. Just see, check it up.
My lords.
15/5, madam.
15/5.
15/5, my lords.
Yes.
My lords. Simple imprisonment for 2 years under section 147 of IPC.
What is this? By the way, this is an appeal.
My lords, no, my lords. This is basically what has happened is the informant, he being a primary school teacher, has side by side, he started a chit fund business. My lords, what has happened is he misappropriated all the money that was collected from the chit fund. Thereafter, in the house in which he was living, he pledged that house, and thereafter he moved to another place. The members of the chit fund, my lord, this business, they, after finding out that he's staying in a different place, they all went together, the present appellants, my lords, to his place. And they asked for the money that was collected because that was their money. When he denied, after that, some little tussle has taken place, my lords, for which reason this case was instituted, my lords.
Then what happened by the judgment which you are referring to?
Judgment, my lords, very peculiarly, my lords, the learned court below has convicted under section 147, my lords.
Convicted all of you?
All of them. 452 and my lords, read with section 149.
Okay.
Well, I also, my lords, 323. Simple imprisonment for 2 years, my lords, under 147. Simple imprisonment for 3 years and 5,000 fine.
No, this is a criminal appeal you have filed.
My lords.
Against commissioner,
No, but how it has come to me? Criminal appeals are there.
Other matters, today, my lord, all the criminal matters.
Sir,
As per the
Next
other
one.
matters, sir.
I will admit it and suspend the sentence, but why are you? I thought something.
No, my lords.
I admit and sentence suspended.
My lords, I have filed 2 IEs, my lords. One for bail application, another for stay of realization of that fine, my lords.
Both are allowed. Both are allowed.
My lords. Grateful.
IEs are allowed. Sentence suspended. Realization of fine is also suspended.
LCR,
bail granted. ठीक है.
LCR my lord, call for that.
LCR, call for LCR. Huh?
Grateful, my lords.
Yes.
17.
May I please, your lordship? My lord, I am BC, my lord.
Yes.
My lord, the petitioner is a juvenile, custody since 25 to 24. While this juvenile along with another person was proceeding, my lord, police has detained them, and from them 36 kg 690 grams of contraband ganja has been recovered. From the adult person, my lord, who is Bharat Kumar, from his possession 22
What is the
kg.
sentence? What is the sentence awarded to you?
Not sentence, my lord. This is special juvenile bail.
No, he has filed the revision.
No, juvenile act, appeal karo na revision act.
Against appeal, I have filed revision.
What is the sentence you tell?
Not
sentence, my lord. This is
juvenile act, my lord. If juvenile court rejected, my lord, then they have to prefer appeal before the sessions court and then only revision in the High Court, my lord. Since my lord sessions children's court rejected, that for that.
Where is the sessions court order then?
My lord, sessions court annexure 1, 2, my lord. Sorry, 1.
Achha,
It page 9.
Let us see the reasoning. Come
My
to
lord.
the
Page 9. On the other hand, my lord, the
yes.
Only because he is a juvenile and he was sent to my lord JJB board. After that, my lord, rejection, my lord, here he has filed.
You are involved in how many cases?
This is the first case, and the co-accused from whose my lord, from whose possession 20 kg, 21 kg has been recovered, he was granted bail by this honorable court. From this petitioner, my lord, 16 kg somewhat.
What is the antecedents?
No antecedent, my lord.
It is case matter. You also may call for the city.
Co-accused have been granted bail, my lord. Your lordship may say, if any antecedent found, this order shall not be given effect to.
You get the CD 28. If there is no antecedent, then I'll release 20 kilo only.
No antecedent and also co-accused release.
Sorry?
Now the election process is going on. The police persons all are busy in election matters. Yesterday I have taken one instruction.
That's right. But see, in this case, he's a juvenile. There is no doubt about it.
Juvenile.
Second is co-accused has already been granted bail.
Yes.
Use that.
Yes, I have supplied, my lord. My clerk is there.
That is, you just check it up. Co-accused has already been granted bail.
BLAPL 3518.
Main accused. He's a juvenile. He doesn't have antecedent as he says. Then he's entitled for bail. Just therefore I'm saying you get it on 28. Give it on 28. Okay. 20. Yes.
Oh, bless.
CD call for 28. Yes.
18.
Lordship 8 on behalf of Mr. Bishwal 18 to 21. All are lordship revision petitions, lordship, and against appellate authority.
Convicted. Under which provision?
Lordship under
all the cases same.
All the 390.
Different accused, huh?
No, same accused, different cases, lordship. Out of audit report, this case has been.
What are you doing, by the way?
Already retired. I'm 71 years old, lordship. Now,
how many cases you have?
For this 4 perhaps, lordship.
No, this 4 is there today here. What about the other case?
I don't have that instruction, but now, lordship.
71 years. What are you doing, by the way?
My lord, he was an accountant inspector of school. So money misappropriation of more than 22,000 in some other cases.
20,000 is very.
Convicted by both the courts.
Yes, ma'am.
Convicted by both the courts.
Both the courts.
And what about your sentences in
2 years, 3 years imprisonment, fine is
5 years?
Fine 2,000, record imprisonment 2 years.
2 years.
Usual order as but I'll not stay the realization of fine. At least You have taken money, give it.
Usual lordship just.
Let it be 5,000, 6,000. Why should I say? He has misappropriated.
But 70 crores, that is the.
So therefore, I am not sending you to jail.
No.
You have minted money.
And lots of, perhaps I am suffering also financial crisis, lordship. No pension, nothing.
You have made many people to suffer.
That's
So,
true.
you have to suffer only.
That's true, lordship, but.
चलो सस्पेंड करो ठीक है एडमिट करेंगे सर हाँ
Lordship, great.
हाँ सेंटेंस सस्पेंड रियलाइजेशन ऑफ वो जो अपील कोर्ट से जाएगा ठीक है
Suspend. Lordship, grateful, lordship.
all from 18 to
21.
20 and leased it. See, I'm leasing it in July
Lordship,
and get ready and argue
I will demand lordship.
because Mr. Raghunath,
Madam?
just see, give that judgment to him.
Sir, file कर bail file करूँगा. Bail file थी और ना. अच्छा bail. ऊपर अच्छा ऐसे अच्छी.
Give that judgment to 71-year-old man. Probation को छाड़ दो काम खत्म. Conviction का फालतू कौन पाए?
My brother will help me, lordship.
Give that judgment. Least it immediately after vacation
Lordship.
and conviction upheld. Sentence also upheld and probation.
Lordship.
So everything is allowed.
Allow. Lordship, grateful, lordship.
71 at least. You should die.
Santeri Bonchu, rest of the life.
Give that. Fix a date. Yes, sir. In this.
Lordship,
I will have to get ready and immediately after vacation. एक गोटे दिन रे allow कर दो आसु.
Aye. Lordship.
Shall I? No. You tell me. Shall I fix on 28th and finish?
Lordship, any day, lordship. Judgment in my favor.
Yes, Mr. Raghunath.
Thank you, Sibo. Now, right?
No, 28th. I'm talking about this 28th.
Lordship, may I ask the copy of the
What I'll do is
photocopy, my lord. Scan copy. Will sir,
give all the copies to him.
Lordship, may directed trial court to give the scan copy.
I'll just pass the order, but you give entire copy to him. I will list it on 28th.
28th.
I'll hear whatever time I can give.
Lordship.
And you prepare facts of every case in one page and give it to me. I'll reserve the judgment.
Lordship.
I'll reserve the judgment and all the I'll allow with probation.
Lordship. Grateful.
One page for every
case. Small note.
2012 supplementary notice to 18 18 ना
18-21 lordship.
18 19 20
मोर मोर আছে তো
কিছু নোটিস করে দাও তারপরে what do you want Mr. Raghunath over there? Trial court is directed to
for the scan copy of the
scan copy of least on 28.
admit hela notice.
So my lord, admit
hela admit for
for
application and share admit कर दियो bail कर दियो and 28 लगा दियो
lordship.
for every case you get one page नहले कोन हबो 24 रेटा
रहियो lordship.
and 10 वर्ष रहियो by that time 71-year-old you will
lordship
go with yes
Belgium matters.
item 22
My lord, bail granted on 20/10/2016. Imbue issued on 28/8/2023.
23
Yes,
500 yes
23 Imbue has been issued, my lord, 30/11/2023.
bail
Bail 25/4/2018.
24
25/4/2018.
24 of 2018 NBW 30/11
2023.
500 କେତେ ଜଣ ଅଛନ୍ତି
କେବଳ ଏନରୋଲ ଡେଟା ଦେଇଛନ୍ତି ବେଲ ଡେଟା କହୁଥିଲେ
500 each
ଏନରୋଲ ଡେଟା ଦେଇଛନ୍ତି ବେଲ ଡେଟା କହିଦେବୁ ଦେଇନାହାନ୍ତି
NBW है ना 30
हां एनरोल ଦେଇଛନ୍ତି
bail date he has said
हाँ
500 each
24
The petition was released on bail, my lord, 21/7/2023, and the NBW has been issued against the petitioner 27/2/2024, my lord.
500
no my lord this is 24
27/2/2024.
that item
Item 24.
item 24 what happened my lord this one will direct him to surrender and release direct the religion bail subject to condition pay the amount my lord. He has not paid the amount. For that reason, his prayer for bail.
now he will go and pay
But that order will remain, my lord.
That
Otherwise,
will remain. I will not alter it.
three installment. Otherwise, my lord, the violatory condition.
Which order is that?
My lord, page, my lord, 17, my lord. 18. The 18 last paragraph. In view of the above order, Honorable Court, the accused persons file an affidavit swearing therein that they shall pay the amount in 3 equal installment.
By order dated 8/5/2020.
My lord.
This court, while allowing ABPL number 3810 of 2023, moved by the present petition, directed the petitioner to deposit, pay the outstanding how much?
Pay the amount.
3 equal installments. Outstanding amount within 3 equal installments.
On 20/11/23 and 20/24.
And fix the date of installment. However, the state order was not complied with.
My lord,
Hence, yes.
My lord, the principal accused, the NDW has been issued against the 2 persons, my lord. The principal accused religion order has been granted by this honorable court, my lord. But either co-accused person, my lord. But similar order has been passed.
That is someone that by that time who was appearing for the state, my lord, he has not pointed to the same, my lord.
But I am not saying anything. He will appear and move application. I will only stay. Whatever the order is there, he has to do it.
Yes, my lord.
Since he has not given the installment, for that is the NBW, my lord.
The principal accused has already given, taken money.
Hence, NBW has been. Mr. Rogada. Mr. Rogada for the state. Mr. Rogada said that he was there for some. Let it counsel for the petitioner in the contrary submit. Then order. Contrary submits that this court, while order dated 2/5/2024 in criminal MC case number 1355 of 2024, has also has cancelled the NBW issued against the principal accused. With that is I am not entering the merits of the case. However, suffice it to say that the petitioner appears for the court below on 30th of June also, and appear of the surrender, and move appropriate application in accordance with the law. Okay. Till then, the execution of NBW gets going to complete. Yes. I have recorded your statement. Yes.
25, my lord, 25 and 26, my lord. In both the cases, my lord, the petitioner is the complainant. This case under 138 of NI Act, my lord. In this case, the accused entered into appearance on the strength of NBW on 5/9/2019, my lord. On that day, he was released on bail, and also on the very day, he filed an affidavit before the Law and Trial Court that I will pay the total amount, 10 lakhs each, my lord. 2 checks. And after 5/9/2019, he has not appeared. Thereafter, MDW was issued, a reminder was given, but till today, he has not been arrested, my lord.
You are the.
I am the complainant, my lord. The petitioner is the complainant.
Where is that last order?
My lord, may I have a glance to page 22, where the accused was released on bail, and on the very same day, he filed an affidavit.
Now, what can I do? NBW is issued, is not executed. That's
my lord, my
simple. Petitioner is the informant in the present case. He submits that the accused, opposite party number 2, had appeared before the court below and assured the court that he will pay back the check amounts. Thereafter, he remained upset. As a result of which, by which order NBW issued?
My lord, that was on 22/12/2021.
What is that? Result is on 22/12/2021, NBW was issued against the opposite party. And counsel for the petitioner submits that despite the NBW was issued way back in despite the fact that NBW was issued on the 2021, December 21, the same has not yet been executed. Executed. The trial court is adjourning the matter repeatedly. Hence, he seeks indulgence of this court. Taking into consideration the aforementioned facts and circumstances, which IIC?
My lord, it is IIC. Chandrasekharpur.
IIC Chandrasekharpur is directed to execute the NBW issued against the opposite party number 1 by the JMFC first class rural cutter in ICC case.
No, that is my lord. JMFC.
I'm reading for you.
Now it has been transferred to
who has issued the check NBW?
my lord JMFC City Cutter.
JMFC City Cutter in ICC case number 102 of 2019, wide order dated 22/12/2021. With this direction, the petition.
My lord, one more grievance, my lord. Let some time may be fixed for a trial. And my lord, at least 6 months. Within 6 months.
Why 6 months? I am expecting it to be done within 10 days. NBW issued there, they have to comply. Why 6 months? Within 10 days, they should comply.
No. Trial to be confirmed.
Trial.
My lord, it's a case of 2019, my lord. 20 lakhs have been.
If that is the case, then I will have to issue notice.
No,
I can't pass expertise. Let it first,
my lord.
let the NBW be executed. Let us see.
My lord.
And he has promised and he may pay also.
My lord.
In the direction of the High Court,
My lord.
if execution of NBW is done,
My
he will definitely come and pay.
my purpose shall be solved. My lord, 26 also same matter, my lord.
26 also same.
My lord.
Date would have changed.
My lord.
The meantime, a proclamation must have been issued.
I don't know. Because NBWs are there. It should be complied. It should be executed immediately. Otherwise, what is the use of NBW issued by the courts? If the police will keep it like this? See how many dates has gone, you just see in the trial court. Awaiting execution. What is this? And in the 138 case, they can't call the police. If they keep on calling police, then it is practically not possible. What is the use of problem? Yes.
27.
May I please? NBW was
Get it executed within 10 days. You take the order, give it to the IAC and say that execute.
Yes, but that from the production of that certificate.
Production of the certificate copy. From the production of the
my lord, NBW was issued 24/4/2024.
Yes.
BL granted 10/4/2023.
Yes. 500.
28.
May I please your lordship, my lord. My lord, NBW has been issued on 27/10/2017, your lordship, page 18, your lordship. The petitioner was on bail by the IO on dated 28/5/2011, page 16, your lordship, kindly.
500.
NBW since 2007. Yes.
2007 NBW.
And in the meantime,
17, your lordship.
17, so 1000.
My lord, is a
proclamation also issued on 21.
my lord, what?
See, I'll tell you one thing. State has no authority to challenge. If the NBW was issued, why have you not executed? You keep quiet. When they come to the court for cancellation, you oppose. You can't oppose.
No, I am not opposing that.
I'm telling you, state doesn't have any authority to challenge. See the other matter. NBW was not executed. At least he has come now. You want to surrender to the,
Yes, ma'am. Let him surrender.
let him surrender and do it.
My lord, is a laborer, 500.
500, please.
My lord.
Yes.
Bail matters. 29. May I please, your lord?
All bail matters.
307 custody since 26/11/23. Your lordship turned to page 13, my lord. Rejection order.
Last.
Nahi, ଟିକେ ରୁହ। କହିଯାରେ ନାଇଁ ରହନି। Page 13, your lordship, kindly.
13, huh?
Yes, my lord. Paragraph 2, Verify the case record towards middle, my lord.
The accused person, namely Niranjan Das and Ranjan Das, threw bombs towards him.
1 minute, one. Let me understand first.
Yes.
Para?
Para 2.
Para
Page 13, para 2.
Yes.
Verify the case record. In this case, being upon written report so and so, informant namely Sunyo Das asked the Ranjan Das about his child namely Sushant Das. The accused Ajay Das gave 2 slap blow to him and pushed Sunyo Das, and as a result of which he fell down on the ground. Then the accused person namely Niranjan Das, your lordship mark, Niranjan Das and Ranjan Das threw bombs towards him, and as a result of which he sustained severe bleeding injury on his left hand, left leg and other part of his body. Bomb was thrown by Niranjan Das and Ranjan Das. So far as the petitioner are concerned, my lord, as per FIR allegation,
Niranjan and
they are not the petitioner here, my lord.
They have granted bail or not? They are on bail.
No, they are absconded, my lord.
And my lord, what happened in this case, my lord? That Ajay and 3 others, my lord, filed their bail application before the lordship, my lord. While your lordship is rejecting 3 of them,
Not
my lord.
Rejecting, your lordship allow the Ajay Das.
How can I understand if he should
complete
So far rejected the prayer for 3 of the accused persons and allow 1 of the co-accused, my lord, and leave with liberty to move after some sort of charge sheet, my lord. In the meantime, charge sheet has been submitted, my lord. Last occasion, your lordship asked me take instruction on whether the about the injury, my lord, the nature of the injury has not been given. For that, your lordship,
I have given the certified copy of injury report that was in record, my lord.
For there, my lord, the nature of the injury is not mentioned. For that reason, your lordship asked me to take instruction on whether the
yes. What is the nature?
What happened when the IO given the
as per my instructions, previous injury, but
let him at least.
Yes.
What happened, my lord? The bomb blast, my lord, they sustained injury, my lord, on a leg or other part of the body, my lord. For that, my lord, since the period my lord, going to be expired, for that charge sheet submitted, my lord. And the final opinion of the injury report has not been, my lord, taken. For that, they pray for another date.
Let's see.
No, I have seen, my lord. I have photographs. Your lordship kindly consider, my lord, for a moment, my lord, Niranjan Das and Ranjan Das threw bomb. That is on record, my lord.
Why have you gone with them? They are absconding.
No. What happened, my lord? Your lordship kindly peruse the FIR, my lord.
Only prayer nature of
in that this leg, there is nothing.
He is moving, my lord, in the village, my lord. That is earlier photographs, my lord. As per FIR story, my name does not find place in the FIR, my lord. Subsequently, I have taken into custody, my lord.
Custody,
my lord.
I am not rejecting. I will not reject. I will give you bail. Wait, happy.
On the
just see, otherwise you want a rejection. The very fact that I made.
Injury report ଫଟୋଟା ଦେଖିଲେ ଆଜ୍ଞା ଜିଏଲ ବାୟସ
ଇଞ୍ଜୁରି ନେଚର ନାହିଁ ବୋଲି କହିଲେ ନେଚର ନାହିଁ
ଅଛି ଗ୍ରିଭିୟସ ଇଞ୍ଜୁରି ଅଛି
କାଇଁ ଆପଣ କିଛି ତ ଦେଇନାହାନ୍ତି
ନାଇଁ ମୁଁ ସାର୍ଟିଫାଇଡ କପି ଆଜ୍ଞା ଦେଇଛି
let the police come and tell me all these things
ଆଜ୍ଞା ଜାଣି ଶୁଣିକି ଆଜ୍ଞା ଇଲେକ୍ସନ ରେ ବିଜେଡି ଇଏ ହେଇକି ଜାଣି ଶୁଣିକି ଆଜ୍ଞା ଦଉନାହାନ୍ତି ରିପୋର୍ଟ ଟା ଚାର୍ଜସିଟ ସବମିଟ କଲେ
ଭଲ ଇଲେକ୍ସନ ରେ ବାହାରିଲେ ଆଉ କାହାକୁ ମାରିବ
ନାଇଁ ଆଜ୍ଞା ଇଲେକ୍ସନ ସରିଗଲାଣି ବର୍ତ୍ତମାନ
ଇଲେକ୍ସନ ଟା ସରିଯାଉ
ସରିଗଲାଣି ଆଜ୍ଞା
କେତେ ଦିନ ଲାଗିବ
28 ତାରିଖରେ
injury sustained by the victims in the present case. Mr. Sahur and Counsel for the petitioner submits that the allegation as per the procedural story the bomb is hurled by
Niranjan Das
and Ranjan Das and the petitioner nothing is no overtake is attributed to the petitioner. Therefore, he is entitled for bail on the ground that other co-accused which is that co-accused
Ajay, that's granted
on the ground that one co-accused Ajay Das has been granted bail, and he seeks parity with Ajay Das, awaiting the injury report to be placed on record by next date of hearing, least it on 20th.
28.
Yes, 28 to 20.
Please, very good.
20. Yes.
20.
Yes. Next.
30.
30.
Lordship 20th June.
Immediately after.
Election sorry.
Nature
of injury. That is
28 there about 80 matters, bail matter. I don't know, till 7 o'clock evening we have to sit. Yes.
May please, Your Lordship.
I am not rejecting therefore. I am giving, but I give it, but wait.
29 and 31, man. 31 same.
31. Wait, you will get it. But record the proper order.
Order judicial order pass.
I'll pass the moment I'll pass, they'll go to Supreme Court and get it settled.
एक केस रे जीव सब केस रे जीव जाके सुप्रीम कोर्ट को उतर के
Lordship pass judicial order for that. We have said that we will after.
Record तो रहुआ, but see.
19th your lordship.
19th, okay, 19th, no problem.
As last chance your lordship. That may be indicated otherwise.
Okay.
I'm on AC.
Stop कहूँगी 3 थर कोइलुन.
नहीं 21 कर दे 21 कर 19 करोड़ 19 पर बहुत 21
First of all.
21st करो 21st.
Item 30 on behalf of Mr. Amlan Shakti, may I please, Your Lordship. Lordship, the petitioner is in custody since 18/10/2023, Your Lordship. 18/10/2023.
23.
My Lord. And offense under section 21B of NDPS Act. 20 grams of brown sugar, Your Lordship. 20
brown
grams,
sugar.
my Lord. 20 grams of brown sugar. And other co-accused by released by this Hon'Ble court, Your Lordship.
20 grams. How much is recovered from you?
Rejection order placed in, Your Lordship.
How to get recovery?
One line, my lord. But how can overcome, my lord, similar nature another case is there. 37 is bar of that. But there are two criminal antecedents against the petitioner. One is the IPC under IPC and another is the similar nature. My lord, 21B and 29 NDPS.
How do you get over it?
My Lord, there are 4 to 5% were there. So no specific ground was there.
You tell me how will you get over the antecedent?
Same, similar offenses.
Any terms and condition maybe.
But you have to get over 37 also. There is a bar.
My Lord, it is below commercial quantity, Your Lordship.
Another antecedent is there, but that is for that is the antecedent call for.
That's the problem.
Below
Similar achi out is it?
But in this case, 20 grams Lordship brown sugar was seized from 4 to 5%, Your Lordship.
I don't know. Immediately after vacation, I'm listing it, but I'm recording everything. The learned cause for the petitioner submits that the 3 accused person. How many of them have got the bail?
I'm supplying 3 of them.
3 I reckon not. You don't know. Bhaiya and others another we don't know. Do we in charge? 4 co-accused persons involved in the present case has already been enlarged on bail by this court, by various orders, the petitioner is involved in the case, wherein 20 grams of brown sugar has been recovered from the possession of all the accused persons.
My Lord, all the accused persons.
Recovered. Mr. Raghuda appears for the state and submits that in all other, in case of other co-accused persons, this court has granted bail because there was no antecedent against that. However, in the present case, petitioner is involved in 2 other cases.
One similar in
one of them is a similar nature of cases. Therefore, therefore, under section 37 CRPC, NDPS is not entitled to bail. Not entitled to bail. let the take file a status report regarding the let Mr. Raghuda see get instruction regarding the status of the case and this matter on immediately CVT. He is in custody since? The petitioner is in custody since?
18/10/2023.
18/10,
Charge sheet already submitted.
and charge sheet filed. See the ground let us see. Undergone age of किसी time तब yes. Double date the row. देखिए date the don't worry. You get a date. Yes.
32.
32, Lordship,
Yes, sir.
earlier occasion, your Lordship directed the petitioner to move after submission of charge sheet. Meantime, charge sheet submitted, Lordship, custody since 12/9/2023, Your Lordship.
12/9/2023.
Charge sheet submitted on 5/3/2024, Your Lordship. And the quantity, Your Lordship, 42 kg, 300 gram of ganja seized from the motorcycle, 2 persons are going. The present petitioner is the pillion rider, Your Lordship. The rider fled away from the spot. The present petitioner court told by
I have granted bail to whom?
no, my Lordship. Your Lordship disposed of his bail application. The present petitioner's bail application directed to move after submission of charge sheet.
Earlier he has filed that one. ELA number 11/20.
Yes.
Yes, what do you say?
And my lord, 42 kg, 300 gram ganja was seized from the conscious possession of the present.
Charge sheet submit headline 12 no roile Lordship. हजुर କହିଥିଲେ charge sheet ପରେ ଆସ.
କହିଥିଲି ତ ସେଥିରୁ କହିଥିଲି ଯେ
So that was premature stage or
Yes.
custody କେତେ ହେଲାଣି custody?
Custody 12/9/23 ରୁ
12/9/23 ହେଲେ କେତେ ହେଲାଣି?
12/9/23 ହେଲେ 5 3
8 ମାସ
8 ମାସ ହେଲା.
1 year job.
Charge sheet
Generally
ପରେ
1 year generally 1 year 50 kg ତଳେ ଅଛି ଦେଇ ଦଉଛୁ.
Lordship 50 consider କର.
Consider I am not rejecting. Don't
Minus.
get the bail. ଆକୁ ରଖିଦେବ ତମେ सेकंड वीक रखो माने रीओपनिंग सेकंड वीक ठीक है सेटल करके दे दो
मैं सीडी लॉस में कॉल
सीडी कॉल करके सेटल दे दो
21 ବର୍ଷର young boy ଟା
ସେଇଥିପାଇଁ
ନାଇଁ
ଏଣ୍ଟିସିଡେଣ୍ଟ କେତେ
ଆଣ୍ଟିସିଡେଣ୍ଟ କିଛି ନାହିଁ
ଗଞ୍ଜେଇ
ଗଞ୍ଜେଇ ଛୁଟିଟା ଥିଲା
ସେଇଥିପାଇଁ କହୁଛି ଛୁଟି ରହିଗଲା ପରେ ଏଟଲିଷ୍ଟ 8-9 ମାସ ହେଇଗଲେ
ମାଇନସ୍
ଭାରି ପଡିବ ठीक है यस
33
ओबले
सीडी कॉल कर दो सीडी कॉल कर
May I please, my lord?
Yes, madam.
In this case, I have filed one IA for the implementation of the victim. I have not implemented the victim as a party. I have implemented the informant, but not victim. So, my IA is filed.
Allowed.
Notice I will take by special messenger.
Notice कर दियो, allow कर दियो IA. Petitioner is permission is granted to petitioner to include the injured as opposite party number 3. Issue notice by special meeting.
One small prayer. My lord, on month of June last working date fix कले से because the victim is staying outside of the state.
कर दो जब अपन जब कोई कोर्ट सरला पर ठीक बस जानतो he will give it. ठीक है? Yes sir.
34
This matter relates to that Baleswar matter, my lord, where the condition was imposed that 2 government sureties are to be there. Yesterday the order passed, but what order? Your lordship may you will fear that the sub collector have that much of audacity. He has again fixed another condition, 1 government surety.
What is this going on now?
I have kindly see that order, storage that order.
Yes, we have given the copy.
What is he trying to play with the court or what?
No. That reason he has stated why he has
He may say whatever reason. What was the order last time? You tell me a person having so much of antecedent, where from he will get government servant as a surety? Which government servant will stand as a surety for him?
Well, another thing, in one of the
due to election, nothing. My lord, he has stated. My lord, can you see that order?
Whatever may be the reason, if the court says something,
since
you arrest him in a other case. Preventive detention karo NIA re. Who stops you? But if court says that what authority he has to do all these things, I'll call him for personal appearance. मजाक करते रही चित्रा करे give the order.
Well, in one of the antecedent, he's the informant. How can a person be judge of his own cause?
Who
Your
is
lordship,
collector?
sub-collector, my lord, Baleshwar.
ବାଲେଶ୍ୱର ଆଜ୍ଞା ସେ ନିଜେ ୱାଚ୍ କରୁଛନ୍ତି କୋର୍ଟର ପ୍ରୋସିଡିଂ କଣ ଦେଖୁଛନ୍ତି still then he is passing.
Prathamesh Raj Sikre. Your lordship, I am giving the one copy of the FIR, my lord, in which he is the
He is
informant.
trying to justify this order by writing 2 pages, 3 pages. In a 110 case.
That is not the question, my lord. Question is, you have, my lord, election is going on, my lord. When the police person went to his house, my lord, he has, my lord, abused the police person.
Do the police are so powerless that they can't?
Then, my lord, he have been remanded in other cases, my lord, in the meantime, my lord. What happened in the meantime, my lord? When he came to before the court, my lord, but while the dealing with the 110, my lord, it presumed that he is doing the judicial work, my lord. He might have obstructed the judicial officer, my lord, and did not want to anything, my lord.
Where have you said those things?
In earlier order, your lordship, on that question, my lord.
Obstructed judicial officer.
My lord,
But I am not on that. What I
refused, my lord.
What I
Refused, my lord. Refused to accept the order of the court, my lord. For that, he went to the said to.
I am not on anything.
My lord.
If the court express the view that in these kind of cases, you don't insist for government surety. Why again justify first government surety 2 ଲକ୍ଷ କହିଲା ପରେ ତାକୁ 25,000 କରି ଦୁଇଟା ତାପରେ ଆଉଥରେ କହିଲା ପରେ ଆଉ ଜଣେ what is this?
ନାଇଁ ନାଇଁ 25 କୁ ପୁଣି 50 କରିଦେଲେ 25 ଟାକୁ ପୁଣି after this court observation he make it 50.
Class 2 पुणी लिखा है जी. Your lordship say class 2.
My lord, 2 of the civilized, my lord, the surety, my lord.
My lord,
2 of the civilized.
they don't twist the court.
Civilized society, all the but government servant, which government servant will take the risk of standing as a surety for this kind of person? You answer me.
Hello. Whole problem is since the election.
And you know the Supreme Court has repeatedly said on the ground of the surety, you can't detain a person.
Hours will count.
And you are doing the
Hours
same
will
thing.
count.
For that,
My lord, the sub-collector himself lodged a FIR against the petitioner. Himself. And he himself admitted the case. You see, this FIR copy I
How can
filing
he be a judge of his own cause? I've given the copy of the FIR, my lord, by filing a memo.
ସେ 6ଟା କେସ୍ ତ ଯେ ଆପଣ ଆରେଷ୍ଟ କରନ୍ତୁ କିଏ ମନା କଲା ଆପଣଙ୍କୁ?
In the meantime, one case, my lord, he has to demand.
ଆପଣ ଜାଣିଶୁଣି ତ ରଖିବାକୁ ଚାହୁଁଛନ୍ତି, ଆମେ ସେଥିରେ କିଛି କହିବାନି, କିନ୍ତୁ ଏଠି
Police
court
has enough
power
power.
କରୁଛନ୍ତି ନା.
ଇଆଡୁ ରିଲିଜ କଲେ ସିଆଡେ ଆରେଷ୍ଟ କରିଦେବେ. That power you have, you do it. But I am talking about 110. If the court repeatedly says, don't insist for it, for one reason or the other, you are passing one order there. I'll issue notice to this collector and pass appropriator. I'll simply say that he shall be released forthwith if he is not needed in any other cases with a furnishing surety
of 50,000 to
50,000 of 2 surety of life.
Also, the bond, my lord, the keep.
ସେଟା ତ 110 ଅଛି. My landed,
Whatever this thing, he'll do it. But
my landed
these
friend
two don't insist for government surety. That's what I have said. Thereafter, you do whatever. I'm not on that. But the court repeatedly saying and see sabotaging the court's order.
He'll give bond.
The officer has the audacity of sabotaging High Court order.
One thing I have lost enlightened my court. I am just filing a copy of the FIR. He himself filed on 6/4/2024. Copy has not been served. If person is come to your office and assaulted him, he was in custody. You have taken to custody.
Let us not widen the scope of this petition.
So I am just saying the intention. You see, even though courts is monitoring very closely, even though court is
SP क्या से
हाँ सब कहिचे आज्ञा
କରନ୍ତୁ ଆଜ୍ଞା but rule of law
ये मना କରୁଛି ଆପଣଙ୍କ
I am not on that.
କୋଉନାହାନ୍ତି କହିଲେଣି ସବୁ ଆପଣ ବାକି ରଖିଲେ.
I am not giving a certificate that he is gentleman. But rule of law has to prevail.
Yes.
If the court says something, you have to comply with it. And otherwise, you could have challenged that order. You have option of challenging it. What was his grievance? Grievance is, please don't insist for government surety. And what is you are arguing? You are arguing he is a very bad man. He is a bad man. Therefore, 5-6 cases against him. Arrest him in those cases. Remand him. detain him under prevention of
On the first
Security Act.
First occasion, my lord, when the court asked him to give bond, my lord, did not, my lord.
My lord, such a unpleasant situation is this sub collector is himself monitoring. Today also he is watching what you are doing. What is the observation in the court?
Yes, definitely.
This is there. He is supplying the link of this officers. So, but it is unfortunate. The observation court is not observed by a IS officer. It is unfortunate. It is a motive of the
name.
what is in the FIR copy there is sir dale FIR kuda hidar achi.
What my senior said, somebody, my lord, that is absolute, my lord, my 29.
Sir diyon to copy
My lord, are not separate, my lord.
He is entitled to see. I am not saying that.
ଦେଖନ୍ତୁ ମା recently I spy ki join କରିଛନ୍ତି ସବୁ ADM ହେଇଥିବେ become smart. Yes.
So misbehave because then you take cause of yourself.
That means he is admitting because of personal grudge he is doing it, not professional work. ତାମାନେ personal grudge ତ ଆପଣ ମାନୁଛନ୍ତି ତାର personal grudge.
Petitioner had filed this petition seeking quashing of order dated 6/4/2024 and 24/2024 passed by the SDJM Baleshwar.
SDM sir.
SDM आप prayer election दी SDM election SDM खाली
LGM सब डिविजनल मैजिस्ट्रेट जेएम टा हम जुडिशियल अफसर आगे जुडिशियल अफसर इले एक कथा कागी दाना चित्त फाड़ दिलु सब तुकी ना ना ओ प्रश्न उठुनी
ସେ ପରା କହିଦେଲେ ଭାଇ ମୋର କହିଦେଲେ ଜୁଡିସିଆଲ ଅଫିସର କହିଲେ କୋଉଠି ସେ ଜୁଡିସିଆଲ ଅଫିସର ଆଜ୍ଞା ଗୋଟେ ମଝିରେ କହିଦେଲେ ହି ହାଜ ମିସବିହେଭ୍ ଜୁଡିସିଆଲ ଅଫିସର ହି ହାଜ obstructed judicial officer ସେ ଏକ୍ସାଇଟେଡ୍ ରେ କହିଦେଛନ୍ତି ସେ କଣ କି my landment is knows everything.
Some decisions are there, my lord, when the master dealing with 110, my lord, as if he holding a
that's why Calcutta High Court given a very drastic comments. This collector that's why Calcutta High Court decision see this similar issue this court has such a drastic words against the magistrate.
He must be, this officer must be a young guy.
Newly
over-enthusiasm is doing so, yes.
Why to spoil his career?
No, that is also not our intention. Let's.
Hence, man,
where is that order? What was the condition? So and so, passed by so and so. The primary grievance of the petitioner has been that the SDM has directed him to furnish 2 government surety for the surety, and this court by the order dated. By the order dated 13/5/2024, permitted the petitioner to move appropriate application seeking various safe condition, the petitioner moved the application, which was partly allowed by the SDM, and directed the petitioner to furnish to 2 surety, 2 government surety of 25,000 to furnish a bond of 25,000 with 2 like sureties who shall be government officers of class 1 government officer. The matter was again taken up on 28/5/2024 and the following order was passed. Pursuant to the said order, the SDM has now passed an order dated 21/5/2024, which has been produced before this court, wherein the SDM has directed the petitioner to furnish 1 government surety and 1 civilian surety of class 1, class 2 and above,
class 2 above
of rupees 5,000 each.
50,000.
50,000 each. 50,000 each. Next one. the said order is, in my considered opinion, the said order is in violation to the direction of this court. And this conduct of the SDU is deplorable, but I am not passing any order which will have a reflection in his career. Be that as it may, the petitioner shall be released on bail by furnishing bail bond of rupees 50,000 and two sureties of like if she is not required in any other case.
He'll give the bond, my lord, stating that he'll not, my lord, create havoc in the locality and also get.
That is the condition of 110. My lord,
Mr. Raghunath,
my learned friend knows.
1 minute, Mr. Raghunath also submit that keeping in view the fact that the petitioner is involved in age many years?
Seven cases.
7 cases, and his conduct during the proceeding, during the present proceeding, he shall be asked to furnish a bond for good conduct. Good conduct. Needless to say that the proceeding under section 110 is pertaining to furnishing bond of the similar nature. Therefore, the petition is directed to comply.
My lord, here one submission, my lord. Actually,
we have filed another
application challenging the
said order.
last order.
It will take with and let's me
pass that.
Okay, good.
Say
I mean, any order to challenge kare je fresh with a file kar deytelu. If lordship is passed it, then there is no need to.
In view of the mention, sheda ko kar degi sheda.
Wrong submission is what tenu.
Discontinue କରିଛି ଭିଡିଓ କରି underline କରିଛି check କଲା refuse କଲା ବନ୍ଦ ଦବାକୁ ଆଉ କହିଲା ଯେ
It is a completely wrong way. On affidavit, you have said that you have not do so. Such a senior official should not tell lie to the court.
Because the delinquent has rejected the option to provide a surety and execute a bond.
ଭିଡିଓ କରିବନି ସେ ତାକୁ refuse କଲା ଭିଡିଓ କରି
Rejected ମାନେ ସେ ଆପଣ କହିବେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଦିଟା ଦିଅ ସେ କୋର୍ଟ ଆଣି ଦବ ମାନେ refuse to like that. This is
Facebook पे ये पठो सेटा सब सेटा
What video he is taking?
मतलब communal मतलब giving speech मतलब communal
ବର୍ତ୍ତମାନ ଯାହା ସାର୍ କଲେଣି ବର୍ତ୍ତମାନ SDM କୋର୍ଟରେ ଆମେ ବେଲର ଖୋଜୁଥିଲୁ ବର୍ତ୍ତମାନ OS ଅଫିସର କି IS ଅଫିସର କୁ ଯାଯିବ କିଏ ବେଲର ହେବେ
Video means what he does?
he giving communal मतलब speeches मतलब here the masjid मतलब and there is likelihood मतलब breach of public tranquility and breach
which officer should not be part of.
He has to give a bond that he will not indulge.
so that
is the requirement of 100.
yes to keep good conduct, keep peace in the society for 6 months.
issue they file ମୋ ପାଖରେ ବର୍ତ୍ତମାନ 4ଟା FIR ଅଛି ଆଜ୍ଞା ସବୁଡା ଲେଖା ହେଇଛି he is giving communal speeches.
He is a leader or what?
he is a Vishwan Parishad activist. And earlier he was working in Vidyarthi Parishad. Now he is jumped to the Vishwan Parishad.
I can see that looking into you people present. But give him why in the election time why he is getting.
He is not doing so. What happened, my lord?
Intention is to keep him inside the court. Nothing else.
Many ways to do it.
Nothing else.
He was present. He was very much present at that year.
That my learned friend knows.
And I think the SGM is not taking advice from Mr. Raghunath. He knows how to.
when he is giving speeches my lord SP won't there my lord it damage the vehicle the SP my lord
Therefore,
it is a fact that he has lost to the office of sub-collector.
And don't be surprised that he will be minister sometimes. And this SP will be, this SDM will be his PA. That will be sure. I'll mind it because he must be young officer. Why to?
No, it's all right. But see the audacity of an officer. He is watching the proceeding of the court. He knows the mentality of the court. We are submitting everything. He was listening everything. Still, then he's passing. This is my predicament is
Again, I am telling you,
senior officer
everything,
should not be like
whatever
this.
you are saying is correct. But is this way to conduct by an executive officer? Highest court of the state is passing an order, expressing a view, but you don't do this. Again, you are doing all these things.
Only intention, he behave good behavior. For that reason,
Now, I think enough has happened. Now he will give the bond.
Obliged.
We'll see that.
Obliged.
Okay.
to maintain peace and public transportation.
Yes, that I am right.
That may be mentioned.
ମାନେ ଏ ଯାହା ହେଲାଣି ଆମର ଲୋକ ତ ଯାହା କରୁଛୁ ଏଗୁଣା କିଛି କମ ନାହାନ୍ତି
Don't say.
My learned friend is going on that he will give bond, and that is the 110 proceeding itself.
Sir,
He is very experienced man. I think he is more excited
today is
in this case.
No.
But his instructions are very, he is holding a difficult brief.
my lord, urgent certificate copy of today.
Today only.
Obliged.
He shall be, because it is a matter of liberty.
Yes, yes. Obliged, man. Obliged.
Okay, thank you.
Your Honor.
Hmm?
Your Honor.
Oh, one.
Your Honor, one submission is there. In a CRL MC 1204 of 2024 Act, in the last date of 16/5 of this month, an order has been passed in which we are the opposite party. I'm standing in person in the opposite party. We are extremely prejudiced. For that, today I filed an interim modification petition, which will be sought on the 20. The modification petition for the modification of the order of 16th of this month.
Now, what was that order?
So the order was that actually to stay the criminal appeal order of 31/22.
I think I have sent it to mediation.
Yes, sir. You sent it to mediation, but up to the next hearing date, that the criminal appeal number 31
Madam,
is been
I
date.
tell you one thing. If some matter is sent to mediation, generally it is said because the court wants that it should not be aggravated. Therefore, it is stayed. If your mediation fails, then stay will be vacated and things will move.
But what
You
happens?
can't have both. You want to settle and go on with the case.
No, my lord. What happens in this criminal petition 31/22? I had a order from the Land District and Session Judge that the opposite party husband is going to give the educational fees of the child and accommodation of 20,000 rupees.
That I might have said that subject to regularly paying the maintenance and all.
No,
I have not said that.
regularly paying means they are paying just 10,000 rupees, which has been filed, and this one is not stayed.
Subject to complying the maintenance order. Must stay.
That one in which the order has been stayed in here now up to the next hearing that is August 29. The child is going to drop out.
Immediately after vacation.
That for evidence, please put up it on 28th so that I can press on 28th.
Next 28th.
The next.
Vacation. I put it on immediately after on 20th. 20th or 21st.
My lord, I am
28 in this month, na?
This month.
Because please, my lord.
my lord, I am praying in my case, kindly fix you 20th. I mean, kindly fix it. That is 13 July, my lord, 2 months. Kindly fix 20th, my lord, it is compromise matter.
Then if you don't bring them on 28th, I'll impose 50
Yes,
also.
yes, my lord, I will bring only to. Kindly.
Your Honor.
The Arjun is like.
No, Arjun is
Oh, that's another problem.
I got petition there.
If there is an, if it is not coming under that notification,
I am positively
Judicial order will pass, my lord.
Judicial order.
We have to file IA.
No, no.
My lord,
No.
So that is.
That's the procedure. I can't go beyond the procedure.
But IA to file कर दिया जी.
Vacation procedure, I don't know. Vacation procedure is this.
हाली हेरी पे file
Everything goes to the Honorable Chief Justice and he allows it. You do that. Follow up the procedure. If it is permissible, then 28th, no problem. I have no issue. You get it done. Get it done. I am trying to do it.
On 28th, ma'am.
I am trying to do it, madam. If it is possible, it is coming within that permissible limit, I'll do it. Don't
Please, my lord. My child will always, it will be going to drop out this year. He is not paying the child educational fees.
Within 20 days, what will happen?
No, on this 28 only, because he will pay. If this order will be allowed, na, he will pay, my lord.
We'll see. We'll see what can.
He has not done the readmission of this year.
We'll see, but
Yes.
35. But try and go and settle it. Finish it up.
He is not
Go
settling
ahead.
out.
Now there is a direction. You go and do it. Go and do it.
I'll do, my lord, but the child will, at least the educational contingency will discontinue this year if this order will drop up to 29th of the August. He is already have not done the readmission.
Then it is permissible or no? I don't. You have to file application because there is a now vacation. You just move an application.
I had already filed IA today.
IA.
IA of a modification petition. Today I already filed. The number came up 1440.
No, early hearing, not modification. And early hearing. Move an application for early hearing also. Otherwise, it will not be.
Memo I have given for the early hearing.
Memo will not. Because the vacation is there is a procedure.
Okay, I'll do.
Please help, madam. Help. She will help. Take. I need to file for you. It have dispose of in terms of this order. It have dispose of in terms of the order. Passing soon. Dispose of. No need. Yes.
May I please? Condonation of a delay minor.
Which one? 30?
5 minor.
Hey, one more matter is also there. Which matter? Yes.
The appellant convicted for a period of 20 years minor. Under 376. 20 years minor.
20 years.
Yes, minor.
Yes.
Condonation of a delay minor. Is inside custody. Condonation of a delay minor. Is
I simply issue notice if we see.
Criminal appeal or lordship passed.
Condonation.
Delay has to be. You don't have any objection. That's what I'm saying. There is a delay in the appeal. So you reply to that. Issue notice on the.
What happened, minor, in this case? In time, the appeal was a preferred minor. The previous lawyer has not removed the defect. As per the standing order of this court, that is dismissed minor. For which
The delay for how many years?
Only 90 days.
I'll condone the delay.
And his argument is that he has earlier filed. That may be taken into consideration.
Where is that I?
That is the 98 of 2024 minor.
101.
DCRLA. I have given
Tell me IA number.
IA number minor 1019.
1019.
The IA number 1019. Allowed in terms of the contention raised by the petitioner, appellant in the application. Allowed in terms of the sufficient cause shown by the petitioner, in the application. Okay, and issue notice in the appeal.
Yes, ma'am. And I am filing an application.
One time, earlier filed application that has been dismissed for non
Sufficient.
Irregular is good. Earlier they had filed criminal appeal matter. There matter the defend not removed. For that for
Dismiss.
That's what he has written in the application.
Yes, ma'am.
I said that the sufficient cause shown in the application. In terms of that, it is.
Just now, serve the copy of the deposition, madam.
Sentence or the lamba sentence. Offense kona?
370 AB. Notice to go.
And that minor child is 6 years.
Notice to go, my lord.
Notice.
Yes, ma'am.
Yes. So then that matter, what do you do? If it's not cured.
Current matter we can dispose of that other matter yesterday
Postpone.
that says that was disposed of.
Already disposed of, no? That is already disposed of.
That different matter will come up.
Defect matter should have filed defect also certificate that way. See, distance with certificate got less. Yeah, that's a problem.
Others just documentation.
Least it's least of rupees. Okay, thank you.